I also want to take a moment now to recognize our outgoing president, Joanna Boyson, who has led us through these unprecedented challenges. Joanna, hopefully we're going to be spotlighting you. And if you could hold up the engraved face that we got you, maybe I believe we sent you a bottle of booze to enjoy, and if you can wave to your fans. So Joanna, you may know, was a past recipient of the FBA Pro Bono Award. So it came as no surprise that she has been a great champion for the FBA Clinic and the Pro Bono program, which have both expanded over the past year. She also has worked toward building the financial stability for the Bar Association. And on a personal note, her sense of humor and her fun stories have added some much needed levity to our meetings over the course of the year. So Joanna, on behalf of the Bar, thank you for your service. Looking ahead, we have an incredible slate of officers and trustees for 2021. Vice President Theo Angelis, Secretary Molly Terwilliger, Treasurer Robert Flanaugh, Trustees Sarah Bryn, Ambika Doran, Malloy Good, Jonathan McFarland, and Tom Vertitas. Together with our dedicated committee chairs and volunteers, the Bar is already hard at work on programming for next year. In addition to the Litigation Academy, in January, we'll have a CLE on the recent changes to the Ninth Circuit rules. There's also a Power Act program being planned for the fall that will be a consortium of the federal, state, and tribal courts. So if you're not a member of the Bar, I encourage you to go to our website and join so that you can participate in all of these programs. You'll also receive, I'll hold this up, a copy of our beautiful newsletter. Hopefully all of the members recently got this. It's beautiful, and it's put together under the leadership of Jessica Andrade. So thank you, Jessica. And now, before I pass the mic, I have a few people I want to thank. Chris Streps at the KCBA and Robin Lipsky at the Ninth Judicial Circuit Historic Society. I want to thank you both for your invaluable help in planning this remote celebration. It truly is a whole new world out there. I also hope that you had a chance to enjoy the guitar performance of Charlie Lassell before we got started. Charlie is a local musician, and of course his wife is FBA trustee Vanessa Power. So thank you, Charlie, for sharing your talents with us this evening. On behalf of the Bar, I also want to express our gratitude to the court, who generously underwrote this event from the court's Bench Bar Fund. We also thank our platinum sponsors, Davis Wright Tremaine, K&L Gates, and Perkins Coie, and our gold sponsors, Foster Garvey, Pacifica Law Group, Polsinelli, Stoll Reeves, Sussman Godfrey, and Yarmouth. The support of our sponsors and ticket revenue will help us pay for the Federal Civil Rights Clinic, equity, diversity, and inclusion initiatives, and all of our other programming this coming year. We thank you all for your support. Well, now that's certainly enough from me. And so now it's my great pleasure to introduce Chief Judge Martinez. Judge Martinez has served as a district judge since 2003, and he became our chief in 2016. In addition to being a respected jurist, his leadership in responding to the pandemic has been acknowledged across the country. He has taken a proactive approach to ensuring the safety of the court and community, while also keeping the wheels of justice turning to the extent possible. He regularly consults with stakeholders from all perspectives, including prosecutors, the defense bar, probation and pretrial services, the prisons, private practitioners, and public health experts. And I've talked with bar leaders in other districts, and it's clear that this approach, while labor intensive, has likely helped us avoid some of the problems that have come up in other districts. So with that, thank you, Chief Judge Martinez, and over to you.
Jamie, thank you. Good evening, everybody. It's so good to see so many familiar faces, even though you're all in those little tiny squares there on the screen. You know, for those of you, I guess the first 100 that were lucky enough to get the little gift boxes that were sent out, this is pretty good stuff. You know, I gotta say, yeah, if you got it, you know what I'm talking about. If you don't have it, too bad. You should have been earlier. Listen, you've all heard that hindsight is 20/20, right? Well, let me tell you, we can't wait until 2020 is in complete hindsight. What a year. What a year it's been. What a challenging year for our personal lives, for our professional lives. You know, my heart aches for all of those people who have lost their lives to COVID. The impact on family, friends, communities, neighbors has been absolutely devastating. I dare say that by now we all know someone who has lost their battle with this, terrible pandemic. And currently, my friends, apparently everything's getting worse right now, and it's going to get worse before it gets better, unfortunately. As you all just heard, our governor just, kept those restrictions going until the beginning of next year. And I don't know when we're going to see the light at the end of the tunnel. Right now, the news is pretty good. The vaccines, plural, seem to be on the horizon. When they'll have enough dosages, I don't know, to get everybody. But at least there's some light at the end of the tunnel. We still haven't seen, I believe, the bad surge from the Thanksgiving holiday. I get it. I am as fatigued as all of you when it comes to this pandemic. We have grandchildren that live less than 8 miles away from us, and I couldn't even have Thanksgiving with them because of this pandemic. So I understand what that feels like. The economic toll it's taken on our city, on many of our small businesses. If you've driven downtown Seattle or even downtown Tacoma, lately, it seems like some scene from some apocalyptic movie. The last 9 months, and it's been almost 9 months since that Friday the 13th, March 13th, when we walked out of the courthouse for the last time. We haven't been back since, not in our normal fashion. It seems more like 5 years, doesn't it? Time just seems to get so bizarre in the middle of all of this. As Jamie indicated, all of you are quite aware, our community, the Western District of Washington, was the hardest hit initially. We were the first ones to shut down the courthouses. I don't know how to tell you how frustrating it was to talk with other chief judges around the country on the telephone right after that happened and hear them say things like, well, we understand why you did it, but we're not Seattle. And I kept trying to say to them, yes, but you soon will be. And unfortunately, that turned out to be all too prophetic. We can shut down courthouses, but we cannot shut down courts. Courts need to continue now more than ever to be able to resolve disputes. And basically, the rule of law is the basis for our entire democracy. And if courts shut down, that is just not going to happen. However, immediately upon us shutting down, my very first goal was to make sure that the health and safety of every person in our courthouses, whether that be staff or people visiting, has always been paramount. And that will continue to be the number one goal in every decision that we make. So what do? Immediately, we started doing the stakeholders calls. We set up a whole conference call every week. We would talk to all the stakeholders, see what was going on. Courts have to continue. We just can't stop. We put committees together to consider how best we could keep operating in the limited fashion that we were. We had to open up at least the lobby area to allow people that don't have access to electronic filing or anything else to be able to walk into the courthouse and drop off things in a physical manner. We did that. We had to safeguard our court security officers and our marshals as best as we possibly could. We put committees together to consider how best to reconstitute going back into the court, or how best to reconstitute remotely if we had to do that. And everybody took the lead. We had so many people that just jumped into that and said, okay, what needs to be done so that we can keep operating as best we can under these limited circumstances. So of course, teleworking, like almost everyone else. Our IT department became even more critical to our operations than ever before. Our staff at every level, every department, have been absolutely amazing. So COVID impact on the Ninth Circuit. We just had a Ninth Circuit judges meeting on Monday by Zoom. Yeah, the whole afternoon meeting. The Ninth Circuit, total cases of COVID since that fateful day in March when we shut down, about 2.5 million now, just in the Ninth Circuit. In the Western District of Washington, we're closing in on 110,000 people infected. The 7-day average now over the last 7 days, 1,756 people on a daily basis. New cases on Monday, 4,100 reported. That surge is only going to get worse. And we're not alone in this now. Actually, we're better off than many of the other states that are going on around the country. The majority of district courts eventually shut down. Most districts right now have paused in-person trials that they were holding or beginning to get back started since the spring of this year. Some criminal defendants in our district have waited years now to go to trial. And I can't explain to you how difficult that is for me as a judge to know that I've got defendants who are sitting pre-trial in detention, waiting to go to trial, and we can't give them a jury trial in our courthouses at this point in time. The Western District of Washington is currently operating under a phase 1 of our initial reconstitution plan. That means no more than 20% of our staff in the courthouses each particular day. We're currently operating under a general order that I signed that limits what happens in the courthouses on a daily basis. Entry screening and face coverings are required. There have been very few in-person hearings in the courthouse, mostly on criminal. And even during those, all counsel, everyone was masked. While counsel were speaking, they had to have a face shield on. We did our best to try to protect everyone in the courtroom, make sure no one got infected. Obviously, we set up contact tracing so that if anyone did come up positive, and that has happened on multiple occasions, especially when people are arrested on some initial offense, they're brought into the courtroom and then they test positive. At that point in time, the agents who arrested them, the marshals who handled them, the CSOs who were in the courtroom, the staff who may have been present as well, everyone has to be extremely careful. We are currently, as I said, operating about a 20% level. We were hoping to be able to open that spigot up a little bit more. And then of course, the Thanksgiving and the holiday surge has hit. And now I'm afraid we're going backwards. But currently, we are conducting all remote proceedings via Zoom. And that includes civil jury trials. We've had 3 of them. And today you'll hear from 2 of our judges that have actually handled those cases. We're also handling non-jury bench trials the same way. We're handling many criminal proceedings. Those things don't stop. We managed to be able to bring in our grand jury at the beginning of the year, in March, when everything stopped. And then we try to figure out how best we can reconstitute the grand jury and bring them in maybe to, instead of the grand jury room, bring them into the 18th floor ceremonial courtroom, have them all spaced out, have everybody wearing masks. And we were able to do that. So that meant that criminal cases, criminal filings and all that's kept going, even though we could not have criminal jury trials. We have no criminal jury trials right now scheduled until after the beginning of the year. But given the current surge, I have to decide between now and literally Christmas, December 24th, whether to issue another general order that maybe shuts it down for another couple of months. And we'll see what the numbers look like in the next week or so before I make that call. As you heard Jamie say earlier, we have 5 district judge vacancies in our district. We are one of the longest lasting judicial emergencies in the United States. The average age of a district judge now trying cases in the Western District of Washington is 76 years of age. We have 3 vacancies in Seattle, 2 in Tacoma. The 3 Seattle positions have been vacant since 2016. Those 5 vacancies carry with them 15 law clerk vacancies, meaning we are actually down 20 positions total in our district. Our district has been working with the Eastern District of Washington to seek support from the State of Washington Department of Health to make the COVID vaccine available at the appropriate time for the judges and court staff. That's been an interesting issue because the Administrative Office of the United States Court sent a letter to the CDC indicating that the federal judiciary and all staff should be considered to be prioritized. I'm not sure how I feel about that on a personal basis. Many of us judges probably fall in various categories of high risk, and we might fall in one of those categories to be prioritized. I'm not sure about that, but when you consider the fact that of necessity, by bringing people together in courthouses, by trying to start up jury trials specifically, we will be bringing many people together into an enclosed space. It sort of makes sense, but I'll work together with our colleagues in the state system and with the Eastern District of Washington to see how we approach that on a united basis. We are working from home, but working from home fits our profession, as I'm sure most of you have found. Civil caseloads have decreased just a little bit, not a whole lot. Criminal caseloads, on the opposite, you may not believe this, but criminal caseloads have actually increased by almost 40% over last year. Let me say that again, 40% over last year, all right? And remember now, we can't try criminal cases. Grand juries are operating, so that the machine is turning. We are very encouraged with the rate of consent that our magistrate judges and our excellent magistrate judges in Seattle and Tacoma have been receiving. You know, when I was a magistrate judge many, many years ago, our consent rate was below 3%. It is now 15% for our magistrate judges. Part of that is, of course, the load on the district judges. But the other part of that is the fact that I think the bar has realized and discovered that we have very, very excellent judges at that level. In August, Judge Layton retired from the bench, and next year, Magistrate Judge Mary Alice Tyler will be retiring in April. She will be available for recall, but we're in the process right now of interviewing the finalists for her position. And by this time tomorrow night, we should probably have her replacement at least in line. The Merit Selection Committee for Article 3 positions under the Biden administration is beginning to be reconstituted. I've been in contact with our senators back in DC. They indicate that because of our judicial emergencies, we want to get in the front of that entire line that may be happening for judicial nominations. The process itself is lengthy. The typical standard time frame from nomination to confirmation has always been about 7.5 to 8 months. By that, I mean, if we happen to be lucky enough to be at the very front, we would be seeing new district judges walking into the Western District probably by late 2021. The load on our senior judges has been incredible. They have done an amazing job in keeping everything going and us operating. I cannot thank them enough for their incredible dedication and willingness to carry the load over the last 4 years. So the very real question is, what does the future look like for us? How long? Even assuming once we get the vaccine, once the majority of us are vaccinated, how long will we need to operate in this limited fashion before a return to some semblance occurs? I never thought I'd say this, but I miss being in that crowded anteroom to the Spanish ballroom and, bumping into all of you and not being able to hear any of you because it's so loud in there. I miss that. I miss that tremendously. But how long before we're able to get back together again? The experts are telling us right now that even when people get this vaccine, you may still acquire the virus. You may not get sick, but you may have the virus and therefore be able to be infectious to other people. Think what that means. We are going to have to be masked in thinking about all of these steps that we're taking right now for a significant period of time. We have our next Chief Judges meeting of the Ninth Circuit set for February of 2021, and that is going to be the number one topic that we will be discussing at that time. What does it look like as we slide back and continue to work into that recovery phase? I'm not sure. We're all in it together. It's good to see all your faces again. I wish so much we could be present in that ballroom, enjoying that wonderful dinner and listening to, all these presentations. I can't wait to get back together with you. And I know that each of you will continue to work hard as well, knowing that the courts remain open and available to serve our community and maintain that critical rule of law, especially in these very, very divisive times. Jamie, thank you. I just want to say that the FBA is recognizing several individuals from our judiciary family. Jamie, did you want me to slide into that now?
Yes, please, go ahead.
Okay. Well, let's see if we can get some of them on screen as I talk about them. So first of all, District Judge Ben Settle took senior status in January of this year. That meant absolutely nothing because he kept an entire full load, and he's promised me that he will keep a full load until his replacement comes on board. So Judge Lasnik made the same promise when he went senior 4 years ago, and he wasn't able to maintain that promise. So not all of them can keep that promise, but I trust that Ben will probably do that. He's been keeping a full load, and not only because it's absolutely necessary, but once Judge Layton retired in August of this year, then Judge Settle and Judge Bryan really became the cornerstones of keeping that whole Tacoma courthouse, going at that point in time and keeping it going now. By the way, the very first remote civil bench trial was tried by 86-year-old Judge Bryan. So who says that old dogs can't learn new tricks, huh? All of us have been working really hard at trying to figure out how to do the Zoom stuff and make sure that it comes across. You'll notice that I rented, Fraser's condo, so that's why you see the background. Okay, if you don't get what that means, ask somebody that's older than you, okay? All right. Judge Settle was appointed by President George W. Bush, one of my favorite presidents, in July of 2007 after working for many years in private practice in Pierce County. He sits at Tacoma, like I said, along with Judge Robert Bryan, and they are anchoring that courthouse. One of the absolute best parts about being a federal judge, especially in the Western District of Washington, is the camaraderie that develops amongst us because we're there for quite some time. Ben is not only a talented jurist and a wonderful individual, but he is my friend, great family. Ben, can you hold up the vase that you were given by the Federal Bar Association? All right, join me in giving Judge Ben Settle a nice Zoom hand. All right, so next, Magistrate Judge Mary Alice Tyler, as you heard, retiring in April. She grew up in Bay City, Michigan, where her father was a judge. She worked in private practice as a labor lawyer in the state of Washington for many years, served as the president of the King County Bar Association. She joined our court in April 2003 and was an integral part of setting up the Teachers Institute. That's a program where every year we bring in 30 to 40 middle and high school teachers from around the entire district. They're invited to participate in an intensive civics presentation by federal judges and others within the judicial system. That program has consistently received the highest evaluations from participants in any program that I have ever seen. Eliciting comments such as, and let me quote, "Best course I have ever taken," to "I learned more about civics in the last 3 days than during my entire lifetime." These are from teachers. The whole point being to teach them about civics and it'll flow to their students and they love it. That program has been absolutely fantastic. Although she's retiring, Judge Tyler indicates a willingness to return from time to time on what is called recall status for magistrate judges to help us out. And so we say, thank you, Judge Tyler, and hold up your vase so you can see what you received. All right, join me in thanking Judge Tyler as well. All right, and then Connie Smith, our former chief of probation and pretrial. Where are you, Connie? There you are. Okay, Connie retired in September of this year. She had actually indicated previously that she was going to retire earlier, but once the pandemic hit, she just couldn't leave us in the lurch. And so she extended her retirement to be able to help us out through the pandemic. She joined our district in June of 1992 as a probation officer, and she was selected as the very first female probation chief in our district's history when our district consolidated probation and pretrial in October of 2010. I was on a national committee, the Criminal Law Committee, and I was lucky enough to become chair for the last 4 years. And it wasn't until I was in that committee on a national basis that I realized what a national footprint Connie had in America. I mean, I was just thought of her as our, probation chief, and I never thought that she was known by so many people. It didn't matter what state I was in or who I ran into. If they were probation and pretrial, they would go, "Oh, you're from Connie's district," and every single time. Not only that, but I don't know how many times I was asked to allow Connie to go to other districts to help them out in whatever selection process they were involved in. She is and has been an incredible leader for us. She walked the walk as well as talking the talk. She also was instrumental in basically preparing her successor, who is now another woman chief probation officer, Chief Monique Neal in our district. I was so lucky to have Connie as one of the critical court unit executives in my tenure in the Western District of Washington. Connie, we miss you. We hope you're enjoying your time off with your family, and thank you for everything you've done. So you got a face too. All right, thank you. Thank you very much. And finally, it was supposed to be a surprise, but you've all seen it now watching the beginning part of the video. Bill McCool, our current clerk of the court, is also retiring this coming June of 2021. He's been with the judiciary since 1996, has served in several other districts as clerk of the court. including Arizona and Florida. He grew up in Oregon, where several members of his family still live, and is a very proud graduate of the University of Oregon. So much so, he is known affectionately to many of his friends as Bill the Duck. In spite of that, he was hired by the Western District of Washington in September of 2010 by many of us Husky alums who really don't care much for ducks. Bill has been an exceptional clerk of the court and the other critical half of my court unit executives during my tenure as chief. You may not believe this, but we literally communicate constantly, sometimes daily on a week, in terms of handling all of the things that have come up, especially with operating multiple courthouses, especially in the middle of a pandemic. From personnel to budgets to dealing with the public to dealing with GSA, whatever may come up, we handle it. Bill has been instrumental in handling each and every single one of these things, especially during this very, very tough time right now. He's also developed a very national profile as well. Part of that is because he was in Arizona, and then he was in Florida as well, and in Washington. So he's got that kind of experience. But the other part is that the respect that has come, because he knows his stuff so well. He has served on multiple national committees, has always represented our district extremely well. He has been a friend of the Federal Bar Association, has supported the FBA at every step of the way. He will be very, very hard to replace. He's an avid golfer and sports fan who I'm sure is looking forward to a much more relaxed pace after June of 2021. Bill, I don't think you got a vase, but I think there's something else that's coming your way.
Yes.
Oh, yeah, that. And Jamie, I thought we were trying to get him a golf club. What happened?
So what we're doing is, first, it's going to be my privilege to present the Federal Bar Association Western District of Washington Service Award to Bill McCool. This service award is only given out on occasion, and it's to acknowledge exceptional service to the Bar Association. Over the past decade, Bill has really become an integral part of our bar. He created the position of court liaison with the Bar Association. He attends all of our quarterly meetings to make sure that we're up to date on court happenings and to give us all an opportunity to ask questions and make suggestions. He's also been a great resource and advocate for our longstanding partnership with the court. And so I spoke with a couple of our past presidents about Bill's contribution and his upcoming retirement. Stephen Masada said, Bill's contribution to the FBA cannot be understated. Roger Townsend added, I never regret when I pick up the phone and just call him. And I think, as Cynthia Jones put it perhaps best, we'll be losing a de facto member of our board when Bill retires. So Bill, we are also, in addition to handing you a little plaque, we know that you're headed to Bend, and we understand you've already scoped out the golf course there. And so we're contributing to the new golf driver that we understand you have your eye on. And we've been coordinating with your wonderful wife, Chris, to make that happen. And so, Bill, I really want to thank you for your service. You are going to be very much missed.
Jamie, you put the wrong head cover on it. It's supposed to be one like this one, this one.
I'm sorry.
Thank you, Jamie.
Think of us.
Thank you, Jamie, for the Strixon 785 driver, which matches my irons, and the Federal Bar Association head cover. It's been a pleasure working with you all, and I will miss you all greatly. Thank you.
Jamie, thank you for giving me this opportunity. I'm sorry if I took too long, and I will turn it back over to you. I miss all of you very, very much. Thank you.
Well, thank you so much, Judge Martinez. Up next, we have Judge Zille and Judge Peckman, and I'm going to do a very quick intro so we leave plenty of time for them to talk. Judge Zille was appointed in 1988 and assumed senior status in 2014. Judge Peckman was appointed in 1999. She was the chief judge from 2012 to 2016 when she assumed senior status. Judge Zille and Judge Peckman have held some of the first remote trials in the country, and we're so lucky to have them here today to share their experiences. And as they're talking, I want to encourage everybody to submit any questions that you have into the chat box. Your questions are going to be collected by our CLE committee co-chair, Duncan Manville. And if we happen to have time tonight, which looks, maybe we're on the fence on that. So if we have time, Duncan may jump in here and ask a couple of questions that you put into the chat. But regardless, We're collecting all of your questions, and those are all going to be addressed early next year at a longer CLE program that Duncan and his co-chair Tom Wong are putting together. And so with that, I'm going to turn this over to Judge Zille and Judge Peckman.
Good evening.
Good evening. I think Judge Peckman's going first.
I am, and Judge Zille and I have the pleasure of talking about the Western District of Washington's latest innovation. I hate to correct our chief judge, but we have now tried 4 civil remote jury trials, and number 5 starts on Monday. You know, our district is really a pioneer. We've been a pioneer in working with juries so many times. For example, we were the first to come forward with an implicit bias video. We also were the first to display evidence in the jury room electronically. And now we are the first to ever have civil Zoom trials in the nation. Now, Judge Martinez asked me in August if I would set up a committee to explore how to do a Zoom trial. Obviously, as you heard, we are not getting back into the courtroom anytime soon. Also, as you heard, even when we do come back, we'll have a huge backlog of criminal cases and they will take priority. I have no idea why Judge Martinez asked this technically challenged judge to take over this project, but when I told my children about it, I got a gigantic LOL back. And they reminded me that I have a hard time setting my alarm clock, but they did acknowledge that I was pretty good at bossing people around. So the first thing that I had to do is I had to collect some great talent. And fortunately, in the Western District of Washington, we have that in abundance. And so we put together a committee, and I have to do individual shout outs to them. Magistrate Judge David Crystal, our IT guru, Tony Duck, our IT trainer, John Frank, our wonderful courtroom clerks, Gail Glass, Lowell Williams, and Grant Cogswell, our amazing law clerk, Catherine Kim, and our wonderful jury administrator, Jeff Humanek, all jumped into the fray to help us solve this problem. Now, I had my own fears about this. There's no place to look for any guidance. None. So playing in my head at the time I took this over was the voice of an old mentor judge that I had. When I first became a judge in 1988, I was assigned the mentor of Judge Robert Dixon. Now, Judge Robert Dixon was a crusty old bull of a man, and I adored him. And I would go into his chambers, and I'm thinking that sometimes I really should have had one of these on because you could hardly see him through the blue haze of smoke in his chambers. But I remember going in with a problem and saying to him, you know, surely you must have seen this before in your 19 years. He says, nope. I said, well, surely you must have seen some problem like this, analogous to this, in your 19 years on the bench. Nope. But this is what he said to me. He said, Marcia, do the best you can with what you got at the time you have it, then go home and say a prayer for the Court of Appeals. So the first thing that we did with the committee is we did a survey. We surveyed 600 potential jurors. And what we found out when we asked them if they were willing to come into the courthouse is the majority of them said they would not. And then we asked them if they would participate remotely, and the majority of them said that they would. The second thing that the committee did is we asked the Ninth Circuit librarian if they would do some research for us, if they would find out, really, is this legal? And what we came back with, just in case you're interested, there is nothing anywhere from any court, anytime that talks about this. There are a couple of articles practical pieces that we're doing some musing about things in the future. But what I guess we found out is nobody says we can't, so we marched ahead. Now we selected Zoom as our platform. We started out in the court working with WebEx. That didn't turn out to be so satisfactory. We took a look at Teams, but we came back to Zoom because we thought Zoom Gov had many of the features that we wanted to have if we were going to do a jury trial. We wrote down every single step of what happens in a trial, from the time that we send out a summons to the time that we get return on a verdict. We walked through each and every step, and then we converted it click by click into the Zoom format. We did a template order that was designed to be a checklist for judges and lawyers to tell them how it is they should go about training, how to organize their exhibits, how to prepare their witnesses, and what they needed in terms of technology. We went through 13 drafts. And then we sent it out to members of the Federal Bar Association to do our first beta testing and review. Got back their comments and incorporated them. Now, one of the things that we were very concerned about is, were we going to be unbalancing our jury pool? Were we going to cut out people of certain socioeconomic background? Would it be a barrier if they didn't have equipment or Wi-Fi connections? And so I made a executive decision that we were going to send out our own equipment if it was needed. And we were going to loan people the equipment. And we were also going to design a training program for those who did not know how to use it to be able to use it. I figured it was a pretty good bet if we sent out our equipment that we were going to get it back. After all, we did know where they lived. So, and I figured ripping off the federal courts was a really bad way to get off on the right foot with the court. So we found that we took those steps to socioeconomically make sure that we weren't cutting people out, and that generationally we were not cutting out. One of the things that came up was the issue of security. And we come to the conclusion that in civil trials, we weren't so concerned about it. Obviously, to me, if the Russians want to hack in to listen to a bad faith insurance case, I said, have at it. Finally, we were worried about public forum. How do we make sure that the public can still participate? Now, Chief Judge John Roberts doesn't believe that we should be broadcasting, and he considers broadcasting Zoom. So what we have done is people are allowed from the public to basically hear the audio, and by invitation, in other words, they can request an invite, we allow them to watch. I have to say that I've been very liberal with allowing people in to watch. And I figure, what is John Roberts going to do to me? Maybe take my parking spot. But I decided that we were going to move forward and allow as many people as possible who wanted to watch us work, continue to watch us work. And I'm happy to say that sometimes on these trials, we've had as many as 200 people watching. That's probably more people than I've ever had in several of the trials here in the courthouse. We reworked our summons to include questions about equipment and familiarity. We reworked jury instructions so that they would be consistent with what we were asking for from our jurors. We started on a handbook, and we then came to the conclusion that we needed to try this out in a mock trial setting to make sure it really worked. So we paid volunteers to work with us over the course of 2 days to give us feedback as we ran a mock trial. Next, we needed to find the perfect trial. And that's where Judge Zille and his wonderful staff sprang into action. Judge Zilli, what happened?
Well, all right. Thank you, Judge Peckman. I want to recognize Judge Peckman for all the work and she and her committee has done. But as a result of that, we were able to try, and I tried what's believed to be the first remote jury trial in the federal systems in the country. And as a result of that, and the work that Judge Peckman has done in the committee and her trials, we have been inundated by requests from other districts to learn what we did, how we did it, and how it worked. I want to tell you about the first trial that we did. It was a case called Dallow versus Holland America. Its cause number, if you're interested, is 19-865, 19-865. It was a case, a civil case, crying out to be tried because the plaintiff was an 86-year-old woman. She'd been on a Holland America cruise. She was injured in an accident when a crewman opened the door, hit her. She fell down, had a brain injury. She had surgery. She was really not able to travel to Seattle. She lived in California, still does. Her lawyers were here in Seattle, but the Holland America lawyers were also in Southern California. And we decided that, and it was set, and we tried it late September, early October for about 6 days. What we had 17 witnesses testify, almost all of them live, but of course remote. Of all of the 17 witnesses, 15 of them lived outside the state of Washington and would have had to come, travel to court, stay overnight, and return. We literally had witnesses from all over the world. We tried the case for 6 days. Prior to trial, we sent out a order for remote virtual trials. If you have a civil case, and if we decide that you're going to have one, you're going to get such an order. The committee helped formulate it. We tailored it to our case, but basically it informed the lawyers about the protocols to be followed, how we were going to proceed, how to prepare for it. And Judge Peckman mentioned this mock jury trial we had. I was actually the judge on that mock trial, and I persuaded gently, I would say gently, I persuaded the lawyers in my case to be the lawyers. So they participated and thus had a heads up, if you will, going into the trial itself. But how did we pick a jury? We brought in remotely 22 people from a panel of, there must have been about 30 that we found were willing. I told our staff that we only needed 22. We went through the same process that we did if they were in court. They were all on the screen. We had, the way I do it is I have literally a script of questions. It's tailored for each case, but I gave the lawyers in advance, as I always do. Here are the questions I'm going to ask. The answers are, it's either yes or no. If it's a yes, they raise their hand. We just record it, and then we go on. When I've finished with my general questions, I go back and essentially interview each of the jurors, starting with juror number 1. You raised your hand to some question, ask about it, ask further questions, and go on to the panel. When I'm through, the lawyers had an opportunity to do their voir dire, and then we had challenges. We ended up with 8 jurors, some of which had been jurors before, some of which had not. We spent a little extra time before trial working on exhibits to see that as many of the exhibits as possible could be agreed to in advance. Every witness who testified, wherever they were given by the lawyers a copy of the exhibits that they were going to be testifying about. So they had that going for them. I think the voir dire in selecting the jury took about 3 hours. That's about the same time that we would take if we were in court. There are some advantages to being in a virtual trial. For one thing, when exhibits were shown to the jury during the testimony, people using iPads, and there was one person using an iPhone, he could zoom in on those exhibits. The lawyers did a wonderful job, and they were able to zoom in as well. But when you're looking at an exhibit, if you're in the court as a juror, you're sharing a screen and kind of leaning over and trying to see what the exhibit is all about. When you have your own device, you're looking at that exhibit close up. And the same is true, they told us, about the witnesses. They were able to look at and see how the witness responded to questions. We had, in this trial, 2 of the most qualified medical experts that I've ever had. One was a neurosurgeon, one was a neurologist, and they were incredible. And after the first, I would say, hour of testimony, you forgot you were in a virtual trial. You were so wrapped up in the evidence that was being presented. So as I indicated, there's some advantages to this remote type of trial. We used an interpreter for the plaintiff, so we dealt with that. We dealt with some exhibits that hadn't been identified, and we dealt with some interruptions during the trial, but they were minor. Occasionally, the clerk would tell me, juror number 6 is no longer with us. Well, we'd go find juror number 6 and we'd bring them back. I think the interruptions were actually less than the type of interruptions you normally have when you're trying a case in court. When we finished, we deliberated, and the jury went into a breakout room, and they deliberated for more than a day. They came back with a $1.3 million judgment against Holland America. And we then had to decide, well, how do we sign the verdict form? Because we, at that time, I don't know if Judge Beckman's committee has figured it out, but we didn't know how to have the presiding juror sign that verdict form. But what we did is we brought the jury in. They emailed the verdict form to me. I looked at it. It was in proper form. I brought them in. I polled the jury. I assured myself that it was a unanimous jury. And then I signed the verdict on behalf of the jury. We interviewed the jury afterwards, and we asked them, well, how did it go? What did you learn? And some of the things they said was interesting. They said, well, we didn't really, until we started deliberating, we really didn't talk to one another. We didn't really know who the other jurors were. And it took us some time to become acquainted and just get a feel for who was involved. We think we can cure that with procedures we're putting in place. But once they said they chatted for an hour or so, they got rolling, and their deliberations were actually easier because, interestingly, each juror could go to the box.com where the exhibits were and look at exhibits. So you could have 8 jurors. They might all be looking at different exhibits that they were curious about and then bringing it to the table. You know, if we're in court, you've got one hard copy they get, They all have to share it. They said, the jury, when we interviewed them, that the exhibits were easier to see on the screen, right in front of you. They said that they could zoom in on those exhibits. They said that the pace was normal. There were really no significant interruptions. But as lawyers, you need to remember to be professional, to have a good background, not your bedroom or your, but some sort of background that's appropriate, and you need to keep going. I found that it was a very interesting case. The lawyers I talked to the lawyers afterwards, and they both felt that they had tried a good case, and they felt that they had been able to have a trial. What I said to the jury at the end, I'm going to read you just a few sentences because it captures, I think, how I thought it went. I said, as jurors, you've done an incredible job of staying with us, coming back if we lost you, paying attention. I know it's not easy, taking the time that you took to go through the evidence in the exhibits. You did. I feel like we had a trial that was good, maybe better than some of the trials I've actually had in court. I said that I want to thank you as jurors for participating. You were wonderful. The parties are obviously couldn't resolve the matter on their own. That's why we have trials. That's why we come to work. And you have helped us resolve the issues and decide the case. And that's what the jury system is all about. And you've performed wonderfully, and we appreciate your service. And then I said, when you leave here, ladies and gentlemen, please tell your friends that the jury duty in a remote setting works. And I hope that someday you'll have an opportunity to be in court as well. I think remote jury trials are here for a while. They work. And I think they're going to be an absolute necessity if we're going to continue to have cases tried and keep the backlog from building up too much. Thank you very much.
All right.
I wanted to follow up on what Judge Zille had to say, because I wanted to, first of all, Judge Martinez, they just turned the lights out in the courthouse on me, so I am now looking at my notes via flashlight. Maybe you can work on that in the heat sometime soon. But I wanted to follow up with Judge Zille's comments, because I now have had trials 2, 3, 4, and about to start 5 on Monday. And many of the things that Judge Zille indicated, I echo. One of the things that I would say is the jurors are incredibly diligent. We had a power outage up in Bellingham with a juror. She got her husband to put a generator together to be able to connect again. And then she drove to the library while her husband did that, to see if she could connect to Wi-Fi. By that time, the power was back on. She drove back home, and we lost about 30 minutes of time while she did that. Also, I would reiterate that the jurors felt that they could evaluate witnesses. And we had one juror who gave me an example of an experience. He had recently been in a distance trial in Mason County. And he says, you know, I could evaluate the witness better because I was looking at them head on and not from 20 feet away. The other thing we found is that more people have responded to their summonses than respond normally. So one of the things that it may be is that we are increasing the diversity of our jury pool rather than decreasing it. And I think that there are some things that, as judges, Judge Zille pointed out, is that they don't get a chance to bond. They don't get to bake for themselves. They're not sitting back there doing puzzles. And so I think as judges, we need to help them with the icebreakers, give them permission to talk. And finally, there's less time wasted. It's cheaper but the lawyers have told me because they're not paying for their witnesses to travel. They're not paying for their experts to sit around and wait. One thing that's lost is the majesty of the courtroom. But I would remind all of us that in times of crisis, federal courts have held court in Quonset huts, in gymnasiums, in community centers, and in double-wide trailers. So we shouldn't get too caught up in the majesty of the courthouse as the only way that justice can be administered. So Western Washington, this is what I want to leave you with. I think all of us should basically do the best we can with what we've got, when we've got it, and say a prayer for the Court of Appeals. Thank you.
All right, thank you so much, Judge Zille and Judge Peckman, for sharing your experiences with us and also for taking the lead in this new and exciting world of remote trials. We are in the proud tradition of the federal bar running late on our program, of course. And so Duncan has been collecting all of your questions, and keep your eyes open for a longer CLE program early next year where we will be addressing all of those questions. So next up, I am very excited to introduce Judge Eric Miller. Judge Miller was appointed to the Ninth Circuit last year in 2019, and he filled the Seattle vacancy when Judge Tolman took senior status. You may have gotten to know Judge Miller before he became a judge. He was a partner at Perkins Coie in Seattle and a Ninth Circuit lawyer representative. Judge Miller, thank you for joining us.
Thank you very much, Jamie and Chief Judge Martinez and distinguished guests and friends. It's a pleasure to be joining you this evening at the Federal Bar Association. I always look forward to this event. It's a little bit unusual, I suppose, to be joining you from the guest room in my basement rather than from a ballroom at the Fairmont Hotel downtown, but we all have to make adjustments, I suppose. I've been asked to speak this evening about the state of the Ninth Circuit, and I want to start by acknowledging a sad milestone for the circuit this year, and that was the passing of Judge Ferris on July 23rd. As many of you know, Judge Ferris was a giant of the Washington legal community. He was appointed to Division I of the State Court of Appeals when that court was first created in 1969, and then appointed by President Carter to the Ninth Circuit in 1979, where he served for more than 40 years. When I joined the court last year, he very graciously welcomed me, generously gave of his time to share his wisdom and counsel with me. And I think my children will always remember that on the day I was sworn in by Judge Tolman, Judge Ferris took the time to engage them in conversation, including a fairly lengthy series of quizzes about math that he administered to them. We will miss him at the Nakamura Courthouse and throughout the Ninth Circuit. This has been a challenging year for everyone because of COVID, and the Ninth Circuit is no exception. I want to spend the rest of my time talking about how COVID has affected the circuit. And I note at the outset, of course, that it's been particularly challenging for a lot of people throughout the country. Many people have become sick, lost friends or loved ones. There are a great many people experiencing financial hardship. And a lot of us are just dealing with the challenges of disruptions to our routines, trying to figure out how to work from home while taking care of young children who aren't in school, for example. And we at the Ninth Circuit have had our share of those issues, but we've been able to carry on with our work. Now, there have been some disruptions. We are a geographically very dispersed court. And so in the normal course of things, we rely on getting together quarterly for en banc week, getting together at our symposium at the Judicial Conference and in regular sittings in order to stay in touch with each other. And obviously we haven't been able to do that since March. So I find that I'm missing my colleagues. I don't get to see them as much as I ordinarily would. It's harder to work within a chambers too. My chambers has been entirely remote since March. And that includes the new set of law clerks who came on board in my chambers, as in most others, this fall. They're all working remotely, and indeed, in my chambers at least, some of them are not even here. I have one law clerk who started in September and is still in Texas and did not move to Seattle. One who is in Seattle, but is spending the month of December in Boston. And we've been able to get our work done, but miss out on some of the personal connection that we would otherwise have. Judge McEwen has explored some creative ways to address that, including having circuit-wide brown bag lunches for law clerks and court staff that I think have been helpful in sort of tying people together and giving them a sense of shared mission. But we do continue to do the work of the court. We're hearing arguments, deciding cases, and we're able to do that using video technology. In some respects, the issues that we face are different from those of trial courts or the district courts conducting trials, like we just heard about from Judge Peckman and Judge Zille. We obviously don't have any of the witness issues or potential questions under confrontation clause or public access that one might have with the trial. In June, our clerk's office put out a press release about our work with video arguments entitled "Tech Savvy Ninth Circuit Leading the Way During the COVID-19 Pandemic," which may or may not tell you something useful about COVID, but I think certainly tells you that the practice of puffery is not confined to the private sector. But as the press release indicates, we've been doing virtual arguments by video since March. We have not canceled any argument calendars. We're sticking to the same schedule. We started with Cisco Jabber. We're now using Zoom. We've had some technical glitches early on. There was one early argument in April, I think, where the internet video worked, but the internet audio cut out halfway through, and so I had to do the second half of the argument using my cell phone. I use an iPad on a music stand to do video arguments, and the music stand is one that I stole from my kids, which created some problems when arguments conflicted with their band classes. We got a second music stand. We've even done en banc arguments by video, and if you want to know what that is like, just imagine the old game show Hollywood Squares, and that's kind of how it works. And we have, in our work, dealt with COVID directly in the sense of having cases that present issues related to the pandemic, which I suppose proves the truth of Tocqueville's observation that there's hardly any question in the United States that sooner or later doesn't turn into a judicial question. So just thinking of my own docket, we have a case about the interpretation of the Families First Act, one of the COVID relief statutes passed by Congress this spring. Also had a couple of cases involving constitutional challenges brought by persons in detention who allege that the conditions of confinement expose them to an unconstitutional risk of COVID. The circuit has also had some cases involving challenges to restrictions on gatherings imposed by state and local governments. And I'm sure there will be more cases related to the pandemic to come in the future. Since there is an interest in CLE credit and in the spirit of offering you some practical advice, I thought I would share, having seen a lot of video arguments and participated in a lot, thought I would share a few sort of practical tips that might be helpful to you if you find yourself in needing to do a video argument, or I think these would be equally applicable to a hearing in a district court. The first is, and these are there are a few things that are probably applicable to any sort of video conference. The most important thing is that we be able to hear you well. And so if you are, if you have an issue with, the way your microphone on your device is picking you up or an echo in the room, consider using a headset with a microphone on it. And I think some people are concerned that that looks a little bit goofy, but I think we're used to it by now. And if it's necessary to get good audio quality, it's well worth doing. Be attentive to the lighting that you have. You don't want to be backlit so that you're silhouetted or have a point source of light that gives you a lot of shadows. You might consider getting a ring light. You can get one for $20 from, I got mine from a local online retailer, but they're easy to find. Pay attention to where the camera is. You want it to be a little bit above you and not too far, away so you're really tiny and not too close. You also want it to be stable. I can recall one argument I had where the camera was positioned in such a way that anytime counsel moved around or gestured or touched the table, everything sort of swayed from side to side. And my law clerks and I referred to that as the Blair Witch argument. Anyway, having said all of this, it's taking a little bit of a risk on my part because it invites you to judge the quality of my setup, which is not above criticism. I think my camera is probably a little bit closer to me than it ought to be. And the reason for that is that if I backed it out, you would see more of the room that I'm in, which includes this sort of dark window well in my basement, and then some of the clutter that's off to the side. And we recognize that you need to make compromises. Everybody's dealing with a lot, and we do appreciate that. I thought along those lines, I can share with you one example of a recent oral argument, in fact, was conducted this morning from a different room in my house in a, I can't share screen because I'm not the host. I thought I would be able to share with you a picture of the setup for an oral argument in the Court of Appeals conducted by someone else in my house who some of you may know. Let me just say that although you couldn't tell it from the Zoom view, from another view of the room, there were an awful lot of Legos on the floor. So those are some generic tips about video conferencing. There are a few that are sort of specific to arguments that I would emphasize. And one is to sort of give some consideration to your background. Some of you may be aware of the Twitter account, the Room Rater, that evaluates the Zoom backgrounds of people appearing on TV. The considerations are a little bit different for an argument because it's nice to have something that's well designed visually with plants and so forth, but really the most important thing is just to avoid distraction. And if that requires just a blank wall, that's okay. You can look, by the way, on YouTube at all of our arguments. You'll see that judges have a variety of different backgrounds, and I think the current environment awaits the return of someone like Dave Latt from 15 years ago to rate the backgrounds used by different judges. Do be careful, particularly if the camera is close to you, with gestures. When you're standing 15 feet away from the bench, gestures are fine. When the change in relative distance between you and the camera becomes greater, you have the potential that your hand becomes giant as you move it in front of the camera, and you want to avoid that. I would recommend sitting down. I think some people may feel that it's a little bit unnatural, but all we're seeing is your head and shoulders anyway. And if you sit down, the little movement from side to side that takes place when you're standing is minimized. and it probably works better. And then finally, I would suggest most people in most arguments, whether in person or virtual, would benefit from slowing down a little bit. That is particularly true in a argument by video. I think I and most of my colleagues are probably a little bit less active in questioning in video arguments than we would be in person. Part of the reason for that is the latency and tendency to sort of talk over people makes it a little bit harder to jump in with questions. But you want to allow the judges an opportunity to do that. So I would suggest slowing down a little bit and being sort of extra attentive to attempts at interruptions for questions. With that, I will conclude by extending to everyone my best wishes for 2021 and my hope that next year we can all be together at this event in person. So thank you.
Thank you so much, Judge Miller. And I am a little bummed that I imagine that was a wonderful video of your wife, Teal Miller, who is an appellate lawyer at the U.S. Attorney's Office. Perhaps we'll find a way to share that. So now on to our featured speaker. Another silver lining to the remote format is that we were able to convince Adam Liptak, the Supreme Court reporter at the New York Times, to serve as our keynote speaker from DC. And of course, once we got him as our speaker, we immediately knew we needed to reach out to Judge Lasnik to lead the interview. Judge Lasnik was appointed in 1998. He served as chief judge from 2004 to 2011 and assumed senior status in 2016. But perhaps more relevant here, he studied journalism before he went to law school. He's a regular speaker at events with the bar and in the broader community. And in fact, he had a very fun interview on the Amicus podcast with journalist Dahlia Lithwick, who spoke at the FBA dinner a few years back. And I encourage you to go online and listen to that if you haven't already done so. So we recorded Judge Lasnik and Adam's conversation late last week, and I will warn you all that we're going to run about 10 minutes over, but I do strongly encourage you to stay with us. Toward the end of the interview, Adam turns the table and starts interviewing Judge Lasnik, and it is not to be missed.
So Adam Liptak is our guest at the Federal Bar Association virtual reception. And you know, Adam, we've been able to do so many things in the federal justice system in the pandemic that have worked out, pretty good, all except criminal jury trials. But this is one time when it really comes very, very short of the real thing. I wish we were at the Olympic Hotel in downtown Seattle with the beautiful holiday decorations and a chance for people to mingle, get together, say hello to each other, talk to you at the cocktail hour, have wonderful dinner. But this is the best we can do. So Adam Liptak is our guest. He graciously agreed to do this. And we promise at some point in the future to get him out to Seattle for one of these great federal bar events where we have all the judges from the Western District of Washington, Ninth Circuit judges who are in town, all the wonderful members of the bar and spouses. It's truly the event of the year. But we'll do the best we can with what we have. We're taping this a week before, so it's Thursday, December 3rd. So if something gigantic happens between now and Wednesday the 9th and we don't touch it, that's because it happened after we did this. But let me start out by saying, for those of you who don't know him, what are you doing here? But Adam Liptak is the journalist lawyer who covers the United States Supreme Court for the New York Times. He's a Yale undergraduate and Yale Law School. Double Yaleys are really great people. I had one who was one of the greatest law clerks I ever had, was a double Yaley. And Adam actually started in the business as a copy boy for the New York Times, literally in the old days when you were running stories out, getting coffee, doing whatever you needed to do for the grizzled veterans of the newsroom. And then after law school, practiced law with Floyd Abrams and his firm, went to the legal department of the New York Times, and then decided to switch over to the reporting side, and did that for starting in 2002. And then in 2008, he took over the beat. Now, Adam, I always talk about when I succeeded Judge Jack Kuhnauer as chief judge, I knew that all I had to do was not lose my temper and scream at people, and I would be hailed as a great chief judge. But it all depends on who you're following. You had to follow Pulitzer Prize winner Linda Greenhouse, who, you know, almost set the tone for modern reporting on the United States Supreme Court. Did you ever wonder, is that a really good thing for me to do, to follow in the footsteps of someone like Linda Greenhouse?
What an astute question. Let me first of all say that it's a pleasure to be here with all of you. I'm sorry we can't do it in person, but I can tell already from the first question that we're going to have a very lively conversation. So I had been the national legal reporter working in New York for about 6 years when Linda decided to retire. And I thought that was very bad news for Liptak because I was happy in my job. I was able to write about legal developments that nobody else was writing about, to shed light on injustices, to roam the country, find cool stories. Journalism, of course, likes the distinctive, likes the new, likes the scoop. And when Linda retired, I had a pretty good sense that my editors would ask me to move to Washington to succeed her. And Judge, as you suggest, that didn't sound appealing to me for at least 3 reasons. One of them was that Linda had such a distinguished career, had covered the court literally for 30 years, and had set a very high standard, and who wants to follow that? I also didn't want to move to Washington. I was very happy in New York, and Washington then and now, by comparison, is a little sleepier and more parochial and more a company town. And then maybe most important journalistically, you're covering the same cases that 25 other very good reporters in the Supreme Court press corps are covering. So it's very hard to distinguish yourself. And in fact, the impulse to distinguish yourself among the sophisticated readership has to be resisted to an extent, because you can't lose the general reader just because you think you have some kind of insight about the workings of AEDPA. So for all those reasons, I hesitated, but then I couldn't figure out really how to turn down what by some accounts is the most prestigious job in American journalism, in part because of the high standard Linda set. And let's not forget also Anthony Lewis, who was also Supreme Court correspondent for the New York Times. So while I am quickly diminishing the brand, the Times has had a long-standing commitment to sophisticated coverage of the court.
And while I make fun of my predecessor, Judge Kuhnauer, he did everything he could to pave the way for me to be chief judge, and was very gracious in introducing me to the right people and telling me what I needed to know. I know.
Let me say just a word on that, because I had a similar experience with Linda. As we were transitioning, she invited me down to sit by her side, to cover some arguments, to cover some cases, and gave me one piece of advice that it has really served me well. She said, when you're reading a decision, always start with the dissent. The dissent will tell you what's really going on. And that's very good advice. It's often much easier to make sense of what the majority is trying to get away with in its kind of placid, you know, the law requires us to do X, and then the dissent will point out that maybe that's not exactly right. So Linda was as with you, was a very fine colleague in transitioning the job.
I noticed that 7 of the 9 Supreme Court justices attended her farewell party when she retired in 2008. How many do you think would attend yours?
I'll be lucky to get one.
But you know, Adam, that Justice Byron White had talked about how it's anytime there's another justice added, it's a whole new court. And just in the last 4 years, we've had 3 new courts, and we're still kind of reeling under this. We've never had a 4-year presidency yield this many justices in my lifetime. I know Nixon had several, but I think it was over a little more than 4 years. But how have you seen the dynamics of the court change with the addition of the last 3 justices?
It's a little too soon to tell. The switch of Barrett for Ginsburg is, of course, going to be very, very consequential, maybe as consequential as the switch of Thomas for Marshall. The only comparable, well, there are 2 comparable switches in recent years. So the court was static for about 11 years until Chief Justice Roberts was appointed. But most of the swaps were ideologically one-for-one swaps. Alito for O'Connor moved the court to the right. Kavanaugh for Kennedy moved the court to the right. But it's really the Barrett switch that's most consequential. I mean, losing Justice Kennedy moved the ideological center of the court to Roberts. And you would have thought that would be a stark move to the right, but the one term in which he was the median justice, the last term, turned out to be a real mixed bag in terms of liberal and conservative results. But now that the Chief Justice has seemingly been thrust out of the median spot, taken over by Kavanaugh, there does seem to be a solid 5 and often 6 justice majority for conservative results. So the writing's on the wall, but we haven't seen the results yet, with the one significant exception of the recent ruling on COVID restrictions on religious services, where the court did change direction as a consequence of the Barrett switch.
And did you think that some of the opinions in that New York case were testier towards the Chief Justice than they needed to be, particularly Justice Gorsuch's?
That's what's known in the trade as a leading question. Yeah, Justice Gorsuch's tone seemed to test the boundaries of civility to me. There had been a lot of frustration on the court that a one justice solo concurring opinion by the Chief Justice in a case from California in May had become very influential. And they, the new majority on the court wanted to disabuse people that was a sound decision. But there was a kind of triumphal tone in Justice Gorsuch's own solo concurrence last week as we speak, the night before Thanksgiving, that actually got the Chief's hackles up a little bit. And there was a tension between the two of them, which suggested that there are some rifts on the court, and suggested that there's been frustration on the right side of the court with what had looked like the Chief's leadership while he was the median justice.
Mm-hmm. And let's talk about the new format of oral argument, which you're probably used to by now, but it's still pretty amazing to see a court that never would allow same-day audio even, as recently as last year when asked to provide it in a couple of key cases. And now you have live audio arguments at the US Supreme Court. And I know some veteran lawyers and veteran journalists like Lyle Dennison have said the format doesn't work, it's not good, it's a bad format. What is your reaction to the format of the Chief Justice really presiding and limiting by time the questioning, but everyone gets to ask questions?
I think it's a good thing that citizens in a democracy have access to the government proceedings. So I think live audio is a great development. The way the court has adjusted to live audio, though, is very frustrating. And I agree with Lyle that it is a very weak version of an in-person Supreme Court argument. So as you know, in person, it's a hot bench. The justices ask questions, talk over each other, build on each other's points, and actually start deliberating at the argument. They haven't talked about the case before the argument, and the main purpose of the argument is for them to test where they are, to try out theories, to kind of work on the case. Chief Justice Roberts, who, as you know, was a very distinguished Supreme Court advocate before he was Chief Justice, said of advocates that their role is to be kind of a basketball backboard. And they're just getting questions bounced off of them. Once in a while, they can get into the game. And from the journalist perspective, that kind of argument is also a very good way to tell where the case is going, because devil's advocates questions are very few. People tend to ask questions only of the side they disagree with. So by the end of an in-person argument, I have a very good sense, if I didn't already, of where the case is heading. Now, the telephone argument version is this. They ask questions in order of seniority. There's a time limit of maybe 2 minutes per questioner. So the chief asks, then Thomas asks, then Breyer asks. And I should pause to say, one benefit of the new system is that Justice Thomas is now an active participant in arguments, and that's great. And he asks good questions. And it's good that he's part of it.
Good question.
So there are pluses and minuses, but you don't have this dynamic process of people reacting to each other, and you don't actually have enough time for the advocates even to give full answers to most of the questions, and it's a frustration. They also, even though the chief tries to keep time, the hour-long argument usually lasts about an hour and 40 minutes. It's not satisfactory. I don't know whether you could replicate by telephone or Zoom the kind of free-for-all atmosphere. And there are people who disagree with me and think the free-for-all atmosphere diminishes the court and is unseemly and doesn't give the advocates enough time to talk. Those are Justice Thomas's basic points. But I actually think that the hot bench in-person deliberation is healthy, and Lyle's major objection early on was that the chief may be playing favorites and was cutting people off. And to a large extent, he's delegated timekeeping to the justices themselves. So very often the justice will say, "I'm sorry, counsel, my time is up." But there was an incident just the other day in the case on President Trump's attempt to exclude unauthorized immigrants from the tabulations used to allocate congressional seats, where Justice Alito, and this was sort of right in the aftermath of the heated discussion over church stuff, tries to ask a question. Chief cuts him off. Alito keeps going. Alito says, "I have a 6-part question."
Right.
He gets through 3 parts. The chief cuts him off. It wasn't a pretty sight, and it seemed to betray the same kind of tension we were talking about a second ago.
And Justice Alito and the Chief Justice got on the bench through the same president, pretty close to the same time. And I didn't see that they were going to be anything but kind of buddies there. But they have definitely grown apart. And Alito's frustrations with the Chief Justice find their way into opinions and arguments. And the Chief's treatment of Justice Alito and that question that you just talked about shows that it's probably a two-way street.
Yeah. When the chief came on, I think September of 2005, Alito January of 2006, so essentially simultaneously. And the political science data showed them to be in the same place ideologically. And they have drifted apart substantially, the chief moving left, Alito moving right, the chief's movement more significantly to the left. And I think that's partly a function of the fact that the chief is the chief. Now, Roberts initially, as you recall, was nominated to replace Justice O'Connor.
Right.
But then Chief Justice Rehnquist died, and President Bush moved the nomination over to the Chief Justice slot. I think an Associate Justice Roberts might well vote much as Associate Justice Alito does. But I think he takes the role of being the custodian of the court's legitimacy and authority very seriously. And I think he means it when he says that the court is not a political institution. And he not only talks the talk, but walks the walk in casting votes that don't always adhere to one ideological side.
Just a little story for the people who are watching at home who might remember it, Justice Roberts was nominated for the Sandra Day O'Connor position when we were doing the Ninth Circuit Judicial Conference in Spokane that summer. And she was actually out fly fishing with Judge Bob Whaley from the Eastern District. And the White House couldn't get a hold of her to let her know about the nomination for most of the day because they were out of the range of cell phone. But that happened when we were there. And that's what we were fully expecting, because Sandra Day O'Connor was our Ninth Circuit justice, and she would come to our conferences. And we thought, wow, we're going to get this young John Roberts maybe now as our next justice. And then, of course, the happened with Chief Justice Rehnquist and so on. But yes, I got to meet Justice Roberts and Justice Alito around the same time because I was trying to line them up for judicial conferences. And they're both nice, really delightful people. It's kind of interesting to me to see how the tension has evolved there. And you mentioned that the Chief Justice might be different if he was Associate Justice. He is somebody who really cares about the history of the court and what it means to be the head of the federal judiciary, doesn't he?
Absolutely. And he has, in his mild and moderate way, stood up for the court occasionally. And stood up for the judiciary when, say, President Trump attacked a judge in the Ninth Circuit, as I recall.
Well, he's right in the audience now. Jim Robart, the so-called.
I don't think the Chief Justice knew quite how big a deal it would be, but that statement that there are no Obama judges, no Clinton judges, no Trump judges, was a very powerful move for him. And he also, for instance, unlike some of his colleagues on the right, doesn't make speeches to the Federalist Society, whereas only weeks ago, Justice Alito gave a very vivid and aggrieved account of the state of the world, and one that kind of predicted how the court would come out in this COVID religious practices cases, because he devoted a large part of the speech to what he said were vast incursions on civil liberties during the pandemic. But even apart from the substance of the speech, you might ask the question of, is it a good idea or not for judges to be addressing in close to political terms either the Federalist Society or the American Constitution Society?
And we've been talking about that as a federal judiciary. Should that be an ethical violation or not? But it's one thing to address those societies in general. It's another thing to bring up your grievances. And that's kind of where Justice Alito may have crossed a line, because you yourself have been spoken to the Federalist Society on multiple occasions. There's nothing wrong.
I do think that there's a kind of misleading and ill-informed idea about what the bulk of the work of ACS and FedSoc are. I do think that they perform valuable work on campuses and elsewhere in bringing people together to have robust discussions of legal issues. The annual gala, the keynote speech, strikes me as a different category.
Mm-hmm. Yeah. So has the new format affected at all how you cover cases, Adam? I mean, you're not with other journalists anymore. You're doing it yourself. Has that had an impact on how you handle? Do you ever call up somebody and say, "Did I hear that right?" Or "Did you have the same reaction I did?"
You know, I don't, and that's a big difference from the press room, where, I mean, first of all, if you're in the room, in the courtroom, with only pen and paper and nothing else to pay attention to, it's sort of easier to concentrate. Whereas if you're on your laptop and you have your phone handy, you know, even though it's an important argument, you may get distracted. So first of all, it's just good to be isolated while you're looking at this stuff. Second, as we walk downstairs, the press corps walks downstairs, we all compare notes. And there's some of, did I hear that right? There's some of, so I count 6 votes. What do you think?
Mhm.
And it's a very sophisticated press corps. And also, we care about little trivial things that you couldn't possibly get in a newspaper story, but that we find fascinating because we're fascinated by every little aspect of it. So I really, really miss my colleagues. And then there's the problem, which I fear might be a problem that survives the court going back, that I'm capable of writing during the argument. And when it became fairly clear in the Affordable Care Act argument that there were 5 votes to sustain the law, my editors started saying, write something right now. And I said, well, I'm trying to listen to the rest of the argument, but you can't argue with these people. And we are a news organization, and that seemed to be news. So I had to write during. But that raises this question. Let's assume they go back on the bench, and let's assume we continue to have live audio. Will my editors allow me to be isolated in the courtroom without electronics when I could get 90% of the same thing by listening to the live audio? So while as a citizen, I think we should have live audio. As a journalist, I'm not sure that works to my benefit. I think
Right.
the exclusive access works to my benefit.
And when you started in 2002, if not 2008, there was not this need to have an instant story, let alone during the argument. You had a chance to piece it together and meet a deadline a few hours away. Now you're under such time pressure to get something to the website as soon as possible.
So when I started, I said, and just to show you how wrong I can be. So, well, I'll tell you one thing, I'm never going to write about a decision before I've read it. Well, those days are gone. And to talk about Linda for a second more. So Linda left the beat in 2008, and Linda wouldn't write for the web. She would get a decision at 10 o'clock in the morning, read it with care, consult with colleagues and experts, have lunch, for all I know, take a nap. And then in the late afternoon, as the sun set over Washington, she'd file a very good story. I am now called on, and this is not an exaggeration, in 5 minutes to file a story that basically is pre-written and just slaps on top one of two or three leads that I've already written. And we publish that immediately, and then I fill it out with a vote count and a couple of quotes, and then I read it. And then about an hour and a half later, there's the first version of the story that's okay. And then by the end of the day, I hope I have written something of the quality that Linda did. But the relationship between readership and quality is completely inverse. Huge readership for that very early, fairly useless story. And our, half a dozen remaining print subscribers on the Upper West Side will get the long version in their paper in the morning.
Right. So do you ever have justices just kind of talk to you off the record, not necessarily about a case, but about the court or about the tone of the discussions?
So I can't get particularly specific about that, but the justices are more accessible than some people might think.
Mm-hmm. Yeah. And
when they have books to sell, or sometimes when they're just in the mood, they will consent to interviews. I interviewed Justice Ginsburg a couple of times on the record, and have talked on the record to Justices Sotomayor, Breyer, Stevens. Maybe that exhausts the list of on the record interviews.
Do you think that when the justices hear about term limits and extending the number of justices and different progressive ideas that were being floated in case we ended up with a large Democratic majority in the Senate, or more than it looks like there's going to be, and a Democratic president, they must have some strong feelings about that, but they seem to be very circumspect about not going there.
Justice Ginsburg did express the view, which I have reason to think is widespread that 9 is the correct number. And she said that publicly. And I don't think the court would be on either side of the aisle, on either side of the ideological spectrum, in favor of expanding the size of the court and starting a tit for tat on that. That seems to be off the table now in any event.
Yes.
Term limits or mandatory retirement ages, I think, would be much less controversial, although in my view, this is not universally shared, would require a constitutional amendment and would almost certainly be grandfathered in, so they could be in favor of that in a way that doesn't affect them. Every constitutional court around the world, except for ours, has one or the other. And, you know, it is a little odd to have 87-year-olds and 90-year-olds working at the court. So I don't think that doesn't strike me as nearly as controversial as expanding the size of the court.
I agree with you that I think it would require a constitutional amendment, whereas the number of justices would only take an act of Congress. But you know, I'll be sitting with the Ninth Circuit in January with Cliff Wallace, who just celebrated his 50th year as a federal judge. He still has a half caseload on the Ninth Circuit Court of Appeals. He'll be 92 when I sit with him. He has 15 children, 51 grandchildren, and 38 great-grandchildren. I think he's looking for something to do.
Right.
But, you know, I've also sat with justices in their 90s who should not have been sitting anymore. And I know this is an issue that we have spoken about on our bench. We're aging. We haven't added a new judge since Richard Jones in 2007. We have openings for five out of our 7 active positions. And I'll be on senior status 5 years this January without a replacement. So we need some help. And it will be interesting to see how quickly we get that help because we're pretty far away from the seat of power, but hopefully we'll get some action. Of course, I'm talking.
May I ask you a question?
Sure.
I mean, the talk in the land is that President Trump was very successful in filling all kinds of vacancies, but is that focused on the circuit courts and not so much on the district courts?
It is predominantly on the circuit court. He has appointed more circuit judges in his 4 years than anyone since Jimmy Carter. Now, Jimmy Carter had, you know, like a veto-proof and filibuster-proof majority in the Senate. But he appointed.
I think the number of seats had just been increased too.
Exactly, they increased the number of seats, and you know there are many women and African American judges throughout the country who got there during Jimmy Carter's time, including Ruth Bader Ginsburg to the D.C.
Right.
Circuit, Mary Schroeder, Dorothy Nelson on the Ninth Circuit, Jerry Farris, who just recently passed away, who was from our area at 90, and but. Yes, the Trump influence is felt much more at the Ninth Circuit Court of Appeals than it is at the district court. But of course, part of the problem is we have 2 Democratic senators. The Senate Judiciary Committee still respected the blue slip for district court, but not for circuit court. And we ended up with some issues there. We have a new Ninth Circuit judge in Seattle, Eric Miller, who will be speaking later during this event, who is wonderful, and we're happy to have him. But our senators didn't go along with his nomination in a way to put together a deal for the district court too. And that I think was a missed opportunity on their part. But
and now we're going to face the question of, let's assume the Republicans retain the Senate, how receptive they're going to be to Biden nominees.
Yeah, and again, I predict that if Lindsey Graham remains Judiciary Chairman, he will defer to home state senators on district court positions, but not on circuit court positions. Right. And we'll see how that trends going forward. Another topic, Adam, that I wanted to talk about is the shadow docket. Can you tell us what cases are in the shadow docket, and how frustrating is that for a journalist to have no idea what the justices have been looking at or why they're making decisions that are just coming out with a one-page up or down?
Right. So the shadow docket has various definitions, but let's use this one. When cases reach the court on emergency applications, typically for stays, sometimes for injunctions, on thin briefing that gets done in a matter of days and is resolved without argument, and often by a one-paragraph order which contains no reasoning, and yet very, very consequential things happen as a consequence. Often the ruling decides effectively for years, perhaps forever. Can President Trump build his border wall? Can transgender people serve in the military? And it's a mess. Such things always happened. Of course, death capital cases often contain just this kind of briefing and resolved in one sentence orders. But for such huge things to happen on this scale is really a change. And I don't have the precise numbers, but the Trump SG's office in its single term filed, I'm making this up, but order of magnitude, I'm right, 28 such emergency applications compared to, again, I'm making this up, but 8 over not only the Obama years, but also the George W. Bush years, 8 total. So very different in scale. Now, the SG's office will say, yes, but we have to deal with nationwide injunctions imposed by single federal district court judges. And such issues ought to be decided. If they're going to be decided nationwide, they should be decided even if on the shadow docket by the Supreme Court. And I think that argument has some force. But still, the amount of work the court is doing in this fashion is disturbing. Now, in the most recent case out of New York on the COVID religious practices case, there was a 7 or 8 page per curiam on such a shadow docket case. So I think that's a good thing. But I also think that if the cases are consequential enough and they're holding arguments by phone anyway, I don't know why phone arguments shouldn't be scheduled on this kind of stuff. Similar, and I don't know that the procedural posture precisely matched up, but in Bush v. Gore and Pentagon Papers, things happen very quickly. But after argument, an argument, as we were talking about earlier, makes a big difference. And then finally, and deeply frustrating to the likes of me, these shadow docket orders come out in all hours of the night. The case out of New York came out 3 minutes before midnight on the Wednesday night before Thanksgiving. I'm glad I was awake. I filed a story, and it was, the biggest story on our website for 48 hours. And as we discussed, not only because of the result and not only because of the change in the result, but because the court issued 6 different opinions and some of them were very testy. So I don't know why that couldn't have waited till, 10 o'clock the next morning.
Mm-hmm. Let's go back to that New York case to ask another question. You have talked about how Justice Kavanaugh had the really one terrible day at his confirmation hearing where he was literally out of control, but that his life before that and since that shows that he's going to be a very measured and intelligent appellate judge. Do you see hope there that somebody like Justice Kavanaugh can align more with Chief Justice Roberts to keep the court from breaking into more bitter rancor?
I share your characterization of Justice Kavanaugh, who does make a point of being civil, does have the right judicial temperament and appears to be open to arguments from both sides, even as his voting record is fairly conservative. He does have an impulse often, and I don't know if this is a bad thing, to kick the can down the road, to find a way not to decide right away. And that, combined with the Chief Justice's occasional moderation, could chart what these days would pass for a centrist path on the court. But I think there's nothing in his voting record really to suggest that whatever his temperament, whatever his open-mindedness, whatever his long game attitude is, that he is anything but a committed conservative on religion, on administrative law.
But wouldn't you have said,
He's Roberts' best hope.
yeah,
because
wouldn't
the
you have
rest
said
of
that
the court-
for John Roberts in 2005, that he was everything that you just described Kavanaugh as?
Yeah, I mean, Roberts, well, they have this in common. So you got to, if you dial it back to before these sexual assault allegations against Justice Kavanaugh, to which he had a very heated reaction, and you know, who knows how any of us would react if we were felt to be falsely accused of such a thing. But before that, his reputation, like the Chief's, was a superb technical judge, someone who was, you know, sort of small p political in being out and about and being part of the social life of the city. Someone once said to me that John Roberts has 4 lunches a day. You know, this it's no longer the case.
Right.
But while he had prospects, he wanted to make sure that he was well liked by people, and a lot of people, including on the left, kind of vouched for him. He seems like such a nice guy. He's probably a moderate, and you know, I think that they were to an extent disappointed early on, maybe more lately, not so much. So it's a complicated dynamic set of cross currents.
Sure is, yeah. And, you know, the Chief Justice chairs the Judicial Conference US, where judges sit in a star chamber and decide issues like cameras in the courtroom and certain matters that have to do with policy for the federal judiciary. And it's interesting because we district judges and circuit judges and bankruptcy judges and magistrate judges all sit on these committees also. But there is no involvement in any of the committee work by other justices of the United States Supreme Court. And I've always found that a little bit unusual, is why not have maybe one of the justices, either by seniority or by somebody who is talented, to be also at the Judicial Conference meetings, and perhaps to work on some of the committees, because you know, these are fairly important issues: court management issues, civil rules, criminal rules, budget, of course, and things like that. But one time we had a Judicial Conference meeting, and the Chief Justice was called away for a family emergency, and there was no one to take over from the court. It was the chair of the executive committee, Bill Traxler, who at that time was Chief Judge of the Fourth Circuit, who took over to run the meeting. And I wonder if it wouldn't help some of the justices to be more involved with district judges, circuit judges, bankruptcy judges, and magistrate judges, because we don't feel like what we do in the trial courts gets much attention or deference from the US Supreme Court justices, most of whom have never tried a case in their life.
That sounds like a perfectly sensible idea to me. I think it would be good on both sides. And I think some, not all, but some of the justices would be quite engaged in this work.
Yes, I agree with you. Thanks. I probably should quit there with getting you to agree with me, but do you have any other questions for me, either as a district court judge or just somebody from the left coast?
Well, I wonder what you think of this critique that in the Trump era, district courts, particularly on the coasts, have done more than resolve particular disputes before them, and have issued injunctions that are broader than the jurisdiction might suggest.
Yeah, that's certainly an interesting, issue. Judge Robart was presented with the first travel ban case in Seattle, and we all know that it was partially chosen because we are the People's Republic of Seattle, and the judges out here have a reputation for being reasonable and strong. And an appeal would go to the Ninth Circuit, of course. So a lot of cases are filed by the Attorney General of Washington or the Attorney General of California to get those cases started. But I think that just as you've been talking about the shadow docket, a function of a White House that has been using it in an incredibly aggressive way, we have been forced to use nationwide injunctions to deal with executive orders that don't go through the Congress, or administrative action that seems to completely ignore the Administrative Procedure Act. And so I see what district judges have done as a reaction to the aggressive nature of what the Trump administration has tried to do in so many areas by bypassing Congress and going directly to executive orders. My case that I had was the 3D gun case, printed gun case. And there, if you don't issue a national injunction, and you're just keeping it to the Western District of Washington, you're not accomplishing anything. So especially now with the internet and with borders not being what they once were, I think that what you've seen has been a legitimate reaction. But it also segues nicely into, wasn't it wonderful to see the Third Circuit Court of Appeals and the district court judge who handled the election case, all appointed by either Trump or W. Bush, and all of these so-called Republican judges, and we don't like those labels, but let's face it, doing the right thing for the right reason. And I was very proud of the district judge, who I don't know, and the circuit judges, some of whom I know, for just standing up and saying it like it is. And then, to have that Trump lawyer, I don't even remember her name, Jenna something or other, react by saying, well, these are activist Pennsylvania judges. What are you talking about? And then we're going to SCOTUS. You can't even say Supreme Court, we're going to all the way to the Supreme Court or something like that. It's like one of my buddies from Staten Island texted me the other day and said, Laz, can't you do something with Rudy Giuliani? He's impersonating a lawyer, can't you do something? And I said, I wouldn't mind if he was impersonating a lawyer. The fact is he's impersonating Bozo the Clown, and that's what's offensive. But I digress a little bit, Adam. But I was proud of the federal judges during the Trump years for doing what they needed to do, despite, Judge Robart had terrible death threats. He needed 24/7 marshal protection. On my 3D gun case, they not only printed my home address, but the home address of 2 of my children on the dark web. And, the Jew judge this and like that. So, I see what happened in Georgia with some of these elections people, and how all of a sudden they're getting death threats and sexual assault threats against their wives. It's tough out there. And, but we're going to persevere, and we're going to do what's right. You as an enemy of the people, I'm sure you get your hate mail and your threats, but we have commitment to do the right thing.
Well, it does seem like these pillars of our civil society, the judiciary and the free press, were tested during these last years. And I think on the whole, we came through in pretty good shape. May I ask you one more question, sort of pivoting off your last remarks?
Please.
The press is sometimes criticized for noting the party affiliations of the appointing president of judges. I usually don't have to do that because everyone knows where the justices are ideologically. And I have somewhat mixed feelings about routinely noting the appointing president in coverage of the courts. But as you just mentioned, Judge, it did add additional force to the Third Circuit election case. So what's the right thing for a reporter to do?
That's a great question. And I noticed online that someone did a study of 89 cases where the issue was religious objections to government imposed limitations through the COVID.
Right.
And of the 89, the Democratic appointed judges all sustained the restrictions. The Republican appointed judges, 36% affirmed the restrictions, and the Trump appointed judges only 6%. So you can't ignore that. That's a fact of life. And
I agree.
That I wish it wasn't so. And I can assure you, if you look at the judges on my court, most of whom were appointed by Ronald Reagan or George W. Bush, only a couple by Bill Clinton and one by Jimmy Carter, you would get the same result in almost every case, no matter who you went to. But that's because we're a unique district where we had a strong Republican senator in Slade Gorton, strong Democratic senators in Scoop Jackson and Warren Magnuson, who really went for merit selection. And now we have a bipartisan merit selection panel. But still, much as I used to fight against that, there's no denying that it is a factor in certain kinds of cases, such as these religious objections to COVID limitations. And I think as a journalist, it's absolutely correct to point those out in those types of cases.
Yeah.
It's fun when you ask me questions. Thank you. You know, I think we'll probably cut it off here. And I want to thank you again, Adam. You have come to several Ninth Circuit judicial conferences as recently as last year in Spokane. And you are exactly what we need to have in this day and age of steadiness, intelligence, experience. You know me, I have the journalism degree from Northwestern and the law degree, and I never got to do enough on the journalism side. I practiced more into the law and the judging. But if we can work out a job share where you did my job for 6 months and I did yours, would you be open to that?
I would like that. I would like that, particularly if it comes with a lifetime appointment.
Yeah. Well, thank you again, Adam Liptak.
It was a real pleasure being with you.
It was really wonderful
Thanks
to
for
do.
having me.
All right. So, Jamie, you want to come back on board?
All right. Hi, everyone again. I hope you all enjoyed that conversation as much as I did. And Judge Lasnik, I know you're out there this evening, and thank you so much for doing that for us. I want to thank all of our speakers and the numerous federal and state court judges who have joined us this evening. You know, although we weren't able to get together in person, it's been great seeing so many faces and names of friends and colleagues. We'll keep our fingers crossed that we can gather again at the Fairmont in December of 2021. And until then, be safe and be well.